First of all, I just want to start with a quote from something called the Russell-Einstein Manifesto from 1955. Here then is the problem which we present to you, stark and dreadful and inescapable. Shall we put an end to the human race, or shall we renounce war? So that we're still limping along and saying, well, no, let's put an end to the human race by not renouncing war and carrying on with it. So I'm just going to deal with the development of the international prohibitions against the use of war and the development of the crime of aggression since the World War II. As you probably all know, after World War I, the League of Nations was formed, and that eventually foundered, and the only thing that was, one of the few things that was kept from the League of Nations was the International Court of Justice, which became a body of the United Nations. So the first prohibition that I'm going to talk about is just in the Charter of the United Nations itself. The Charter of the United Nations, Articles 2, obliges all member states, of course, of which virtually all the countries in the world are members of the United Nations, obliges member states to promote international peace and cooperation, promote respect for international rights and freedoms, and to forbear from the use of force to settle disputes. And, people could say, so for instance, all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state in any other manner inconsistent with the purposes of the United Nations. Just bearing in mind that one of the purposes of the United Nations is to ensure that people around the world have the equal right to exercise protected rights. So, in other words, just starting from the right to life, so that makes everything make sense. Now, you could say, well, so what? The International Court of Justice, that's the court that the United Nations court to which states can refer matters of disagreement and conflict for rulings. And in the Nicaragua versus the United States case, the International Court of Justice described the prohibition on the use of force as a peremptory norm of international law from which states can't derogate. Now, peremptory norm is just an overriding principle of international law that's considered so fundamental that nobody's supposed to deviate from it. So that's what the International Criminal Court had to say about that. That's described in Article 2 of the Charter, and none of the situations regarding Afghanistan, Iraq, Syria, or Libya involve United Nations Security Council resolutions that authorize the use of force. When we get to those things, I'll be saying, yes, there's sometimes when states said, oh, this did authorize the use of force, but not even a particularly careful reading of whatever the resolution it was clearly indicates no such thing. So that's the number one thing. And number two, the Article 51 of the United Nations Charter preserves the right of states to engage in self-defense. And so both of those exceptions, both the UN Security Council authorization and the right to self-defense, they're both fairly narrowly interpreted. Now, as far as, I'm not going to suggest that the UN Security Council operates properly. I'm just going to tell you what it is supposed to be. So under the UN Charter, states are supposed to act collectively to maintain world peace and to ensure fundamental rights. So the Security Council is supposed to be one of the bodies of the collective will of the United Nations. So it's a body of the General Assembly, which is all the members. And so the Security Council obviously can't authorize the use of force that's inconsistent with the UN Charter. And all of the uses of force that I'm going to be referring to in Afghanistan, in Libya, in Syria and Iraq have been a kind of use of force that even if there were an underlying legal justification, which there hasn't been in any one of those situations, still the use of force would be in violation of the UN Charter because there's no plan to it. It's force. So one of the restrictions on the use of force under international law and under, say, the right to self-defense is that the contemplated use of force has the capacity to defuse the threat, and to so it isn't. So it suggests a sort of a planning that has to go into the use of force. You can't just destroy the entire country and say, well, we did that because we thought Osama bin Laden was there, and we were interested in getting him. The right of self-defense, I'm just going to run down these little things and you'll hear those words that Mr. Harper says. So there's a number of factors that have to be in place. So the planned use of force has to be in response to an armed attack, and the armed attack itself has to be something that's reasonably subject to proof and lack of fabrication. So it has to be, in other words, some real attack that's either ongoing or imminent. It has to be necessary to defend against the attack, the only means of an adequate defense, proportional to and limited by the demonstrated necessity, and temporary and used only until the UN Security Council has taken measures necessary to maintain international peace and security. There's been references in cases to what these terms mean, and I won't go into any of them, but a case that probably an International Court of Justice decision that many of you are probably familiar with, the legal consequences of the construction of the wall in the occupied territories. The International Court of Justice, one of the defenses that Israel had put up was that they had to build the wall was necessity, and the court rejected that, saying that necessity can only be invoked under certain strictly defined conditions, which have to be cumulatively satisfied. And one of those conditions, that the planned use of force had to be the only way for the state to safeguard against a grave and imminent peril. So if you just keep that in mind when we get to the Canadian situation. Now, collective self-defense is also a right that's preserved, but it's much more controversial, and it's subject to the same conditions as the right to self-defense, but it can be, collective self-defense can be invoked when a state under attack, and an attack fulfilling those circumstances that I just talked about, invites another state to assist them with self-defense. But then it's also something that has to be necessary, has to be reasonably capable of actually being a defense to the attack, and has to be proportional. So all those things would have to be. And that's important to think of when we get to the Iraq situation. Article 52 of the United Nations Charter is absolutely silent about whether self-defense includes the preemptive use of force. In other words, entitles a state to take action when an attack hasn't actually occurred, commentators and scholars, I'm not talking about military people, I'm talking about people who study these things, are divided on those issues. But in the main, the more serious scholars come down on the side that it isn't, it would make nonsense of the other provisions if it were allowed, and so they're saying it is illegal, and they're saying in any event, if it were legal, it would have to comply with the same restricting conditions as the use of self-defense. Another issue, of course, that's controversial is the use of force against non-state actors, because all of the law up to a certain point was just talking about the use of force against state actors, and that's the situation that you have in Iraq. And that's a subject that's very controversial. I'm going to treat it, for the purposes of my comments today, as if it were allowed, and I'm going to say that even if use of force against non-state actors in the territory of another state being harbored were allowed, that's not the situation in Iraq that allows Canada to be legally there. So then what happened after the UN Charter, which was in 1945, Canada joined the UN in November of 1945. Other developments, so that was just the prohibition of the use of force, then the development of the crime of aggression, making war, that is. First of all, we had the Nuremberg Charter, the Nuremberg International Military Tribunal, whereby the Allies set up a court and a charter and so on in order to allow them to prosecute individuals of the Axis powers and the Nuremberg Tribunal described war as the planning, preparation, initiation, or waging a war of aggression or a war in violation of international treaties, agreements, or assurances, or participation in a common plan or conspiracy to do the same thing. So that was very general. And then after that, the United Nations General Assembly passed a number of resolutions prohibiting the use of force in 1970, 1974, 1984, 2002. Before 2006 came along the Rome Statute, and the Rome Statute was agreed to. The text of that, that's the statute that creates the International Criminal Court, and the text of that statute was agreed to in 1998, and then the court took jurisdiction over genocide, war crimes, crimes against humanity, and the crime of aggression. But anyway, so what part of that deal was is they said, okay, we're not going to agree on the we're not going to agree on the definition of the crime of aggression for another 7 years. And so then they finally got together in Kampala, Uganda in 2010, all the parties to the Rome Statute, and they agreed on the definition of the crime of aggression. And so now the Rome Statute has been amended to include that, and but the court won't take jurisdiction over the crime of aggression, the International Criminal Court, until January of 2017, and 1 year after the 30th country has ratified the Kampala Agreement, the definition of aggression. So first of all, I'm just going to tell you what, just a couple smattering of how it defines it. Aggression means the use of armed force by a state against the sovereignty, territorial integrity, or political independence of another state, or in any other matter inconsistent with the Charter of the United Nations. And that it includes 8 different separate categories that qualify as a crime of aggression, one of which is the invasion or attack by armed forces of a state of the territory of another state, or any military occupation, however temporary, resulting from such invasion or attack, or any annexation by the use of force of the territory of another state or part thereof. Number 2, bombardment by the armed forces of a state against the territory of another state, or the use of any weapons by a state against the territory of another state. So you can see the definitions, and then it goes on, are quite broad, and they certainly capture all the stuff that's going on in Iraq and Syria at the present time. Now, at the present time, Canada hasn't signed the Kampala Agreement. 24 countries have, and that's as of this month. Yeah, 24 countries have, so there's only 6 to go. So it looks like they'll make the court should be able to take jurisdiction over the crime of aggression within the next, say, 18, by January 1st of 2017, because that will fulfill those 2 conditions. I just want to put to bed the question whether international law authorizes the use of force in the territory of another state to combat terrorism, and the answer is a huge, big, loud no. There's over a dozen anti-terrorism conventions in the United Nations, and virtually every resolution that the U.S. and Canada and others rely on as authorizing them to use force usually say that they all say that they should be acting cooperatively under the conventions to eradicate criminal activity and bring the perpetrators to justice, and so using that kind of language. There's not a whisper of saying they should go out and bomb everybody. What kind of legal obligation does Canada have? Canada has a legal obligation arising out of a whole host of instruments, including the Charter of the United Nations, all 4 Geneva Conventions, the 2 protocols to the Geneva Conventions. Canada's signed and ratified those, the Rome Statute, and other, and also Canadian law. It has a legal obligation to promote peace and to settle all of their conflicts and disputes by nonviolent means, and not to invade the territory or the political integrity of other states, and to ensure human rights. Now, all 4 of the Geneva Conventions prohibit violence against. Just to say, now, if we're not concerned, in addition to the prohibition against using force against other states, Canada is also prohibited from using force against other people. Just as, they couldn't roll out the troops and come and mow us down in this room because we were talking about their illegal activities. So they can't do that anywhere. They can't crash into the house of, they can't legally crash into the house of a family in Afghanistan and take the adults off to prison, or they can't bomb that or kill the people or do anything else like that. Okay, so all 4 Geneva Conventions, for example, prohibit the violence against any persons not taking an active part in hostilities, and this includes combatants outside of combat for any reason whatsoever, for injury, for laying down of arms, or say people that are in a detention facility. So bombing prisons has recently happened, obviously is just an outright crime. And the Geneva Conventions imposes a mandatory duty on Canada and everybody else that's party to it to collect and care for the sick and wounded. So there you are when Canada's bombing from the air. Even if their bombing from the air were completely legal, which it isn't, they're still in violation of all of their legal duties because they're not doing anything about the sick and wounded, however the sick and wounded could possibly be described as combatants or non-combatants, or it doesn't really matter, because once they're sick or wounded, the Canada's obliged to take care of them. One of the first protocol to the Geneva Conventions says, for example, expressing their conviction that nothing in this protocol or in the Geneva Conventions can be construed as legitimizing or authorizing any act of aggression or any other use of force inconsistent with the United Nations. Now, Canada's ratified the Rome Statute. They've passed the Crimes Against Humanity and War Crimes Act, and they've ratified the Geneva Conventions and passed the Geneva Conventions Act. And in accordance with their duties under those statutes, they've enacted the jurisdiction to prosecute any crimes under those acts. No matter where the acts are alleged to have occurred, and no matter what the nationality of either the suspected perpetrators or the known victims. Okay, so then the National Defense Act, I'm just going to briefly jump to that. That's Section 31 of the National Defense Act, that this might shock you, empowers the Governor General and Council. Now I just want to quickly tell you who the hell the Governor General and Council is. That's the Governor General, that's in other words Elizabeth's representative, the current Elizabeth's representative, acting on the advice of the federal cabinet. So that's a pretty secretive and strange process. But anyway, Section 31 empowers the Governor General and Council to authorize military action in 3 circumstances: emergency self-defense, actions under the Charter, or actions undertaken under NATO or other agreement. Now the NATO and other agreements thing is slipped in there, but for legally we don't have to worry too much about that, because you'll probably remember when Canada invaded Afghanistan, the very first excuse they gave was they said, oh, we were operating under the North Atlantic Treaty and under the Washington Treaty, which was a whole lot of hokum. And both the UN Charter says any regional organizations such as NATO have to act in accordance with the Charter. The North Atlantic Treaty says the North Atlantic Treaty Organization has to act in accordance with the UN. You know what I mean? So it was just a lot of it was lies, actually. Okay, since 2001, Canada's engaged in the use of military force and been part of wars of aggression as defined by the Kampala amendments to the Rome Statute in Afghanistan, Libya, and Syria. Canada has never been the subject of an armed attack from any one of those countries. They've never been the subject of an armed attack from any non-state actors harbored by any of those countries. They've never been threatened with attack by any one of those countries. So a right of self-defense doesn't even come into it at all. Within weeks of the September 11th attacks, Prime Minister Chrétien announced that Canada would contribute militarily to the U.S. invasion. It had started before, but he announced it then. The U.S. had called their illegal operation in Afghanistan Operation Enduring Freedom. It's really enough to make you cry, isn't it? It's terrible. And the deployment of 2,000 naval troops began then on October 7th, right when the bombing started. In mid-November 2001, ground troops were placed on notice for deployment to Afghanistan, and in January 750 soldiers were sent over there. But before that, in October, they'd sent over a group of Joint Task Force people. Now, what excuse did the Chrétien give? Well, he never gave any excuse. Obviously, they were going at the invitation of the United States, and every single one of these involvements has been at the invitation of the United States. Then Prime Minister Eggleton said that he was acting under the NATO treaty, the North Atlantic Treaty, and so on and so forth, but that was all nonsense. The really dreadful problem right now with Afghanistan is we don't know what Canadian troops are doing in Afghanistan right now. We were told that they stopped all their combat missions. All of their combat missions started with A. There was Athena and Apollo and a bunch of other Greeks there. Their combat missions, those are the missions where they were actually working for Operation Enduring Freedom. They were also part of the International Security Assistance Force, and I'm not talking about that. That's a whole other thing that I'm just talking about. They're helping with the U.S. right now. we were told that their combat operations ended in 2011, and there's little ceremonies and weeping and, you know, flags waving and everything, and the brave boys coming home. Then we were told in 2000 that they were just going to be training exercises. Then we were told that their training exercise all closed down. What a sadness that was, in March of 2014. But you know what? They're still there, and they're there. Let me see if I can find the quote of what they're doing. It's very secretive. Oh, here we are. Okay. A spokesperson for the Canadian Armed Forces, Captain Sullivan, recently told Embassy Magazine that the CAF is deployed at the Department of Foreign Affairs at their request, and that the CAF are, quote, serving in support functions at the Canadian Embassy, and are also serve in a variety of individual exchange positions with Allied forces in Afghanistan. But the secrecy surrounding them is very different from, like, there's Canadian Armed Forces at embassies all over the world, and you can find out about that very easily, but you can't find out anything about this. Now, one of the reasons why that should concern us all is we don't know whether or not Canadian Armed Forces had anything to do with supporting the recent bombing of the hospital in Kunduz in Afghanistan, of the Médecins Sans Frontières hospital on October the 3rd. Now I see I'm totally running out of time. I don't have time to tell you about. Let me just quickly tell you about Iraq and Syria. Well, no, I just want to say this, is that Canada's illegally in Iraq and illegally in Syria. They don't have any legal justification whatsoever. There's never been an invitation to Canada by the Iraqi Prime Minister, even if you said that, oh God, he's a real Prime Minister. Actually, he was just slipped in moments before they got rid of one puppet and slipped in another one. And anyway, but his invitation, even if it could be considered an invitation to the U.S., which in my view it isn't an invitation, could never be considered as an invitation to Canada. Even if it could be considered as an invitation to Canada, Canada has breached that invitation, because even the puppet guy in Iraq has said there's going to be no combat troops on the ground. So Canada sent in its 69 special forces people who are engaged in combat, and guess where they're engaged in combat? Up in Erbil, up in northern Iraq, where they're helping the Kurds. And so then just recently, at the end of October 28th, there's a Canadian plane leaping over up to Erbil from Kuwait. They stopped down at the Baghdad International Airport, but then the Iraqi people want to see what's on the plane, what's the cargo, okay? So then they detain the plane till the 31st of October. They finally let it go. Canadians say, well, we were able to work something out. Yeah, they sure were. They were sent right back to Kuwait. But then this flew up a lot of controversy, because one set of Iraqi military and government people said that that the U.S. was trying, through Canada, to arm the Kurds who were going to use those arms. Oh, because I forgot to tell you, the plane was full of arms, who were going to use that to break away from Iraq. And then another group of Iraqi people, military and government people, said, no, this is part of the movement to arm ISIS. So there you go. That's what Canada's, those are the kind of slippery things that Canada's involved in.